Good afternoon, and thanks for joining us for a Tax Practitioners Board webinar. My name is Ashley Dowsard, and I'm hosting today's session. Today, I'm joining you from Ngunnawal and Ngambri country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to land, waters, and community. I'd like to pay my respect to them and their cultures and elders, past and present. To begin, I have a few quick housekeeping messages. First, to access today's slides, you can visit our Webinars Resources Hub at tpb.gov.au/webinar-hub. We'll also email you a copy of the slides following the webinar. Today's webinar counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we will issue an attendance certificate to those of you staying online for the webinar today. In today's webinar, we'll be discussing why client verification is important. We'll look at what the requirements are to verify a client's identity and what evidence is needed, document verification checks, and what to do if you identify a discrepancy, what to do with clients without conventional identity documents, and some real-life case studies. We'll also look at engagement letters, why we recommend them, and what to include when you use them. Then, to finish off, we'll answer some of the questions we received during the webinar. To help with that, we have Nadia and Daniel from our policy and legislation team. They'll be responding to your questions as we go, so please submit them using the Q&A. To find the Q&A, simply move your mouse over the screen and a range of icons will appear. You can disable any of these functions today by simply unselecting Show Preview. We will also be turning off the chat once we get going to minimize disruptions. Before we begin, I'd like to introduce our speaker for today, TPB board member, Deborah Anderson. Deborah is a registered tax practitioner with extensive experience as a BAS and tax agent. Deborah, over to you.
Thank you, Ashley. It's great to be here today. And thank you to all our practitioners that have joined us today. I know many of you were on the earlier webinar today, so thank you for coming back. Before we get into today's webinar, I just wanted to give you an idea of why we're running this particular session. We decided to run it because after the last tax tips session that we did 2 or 3 weeks ago, we received a lot of questions about proof of identity and the use of engagement letters. So we thought we'd hold another webinar just to flesh those issues out a little bit more and make your 2024 tax time a little easier. So my aim today is to help you understand how engagement letters can help you and also help your clients and provide that clarity for the proof of identity requirements. That way you can take the appropriate steps to verify your client's identity, which in turn will help to protect your business, your clients, the Australian community, and our tax and super systems from identity fraud. We're all working in an environment where remote working and the increased reliance on technology are becoming the norm, and tax practitioners like yourselves are no exception. The environment increases the risk of fraudsters attempting to steal people's identities, which can be used for a whole range of things, including criminal activities such as tax fraud. Each one of us has a responsibility to protect the Australian community and our tax and super systems from identity fraud. The TPB have worked closely with the ATO in developing our guidance so that both the ATO and the TPB's guidelines are as aligned as possible to minimise any burden on you. Importantly, We want to help you enhance your client verification processes so that you can minimise the risks of inadvertently falling victim to identity crime. So it's important to know that while there may not be any specific proof of identity requirements under the Tax Agent Services Act, there are a number of provisions that you may breach if you fail to do the appropriate proof of identity checks to verify a new or even an ongoing client's identity. This includes verifying the identity of any representative or of a new or an ongoing client, and the representative's authority to represent the client if applicable. So the code items that would be considered are Code Item 1, Code Item 7, and Code Item 9. So Code Item 1 is acting honestly and with integrity. Code Item 7, ensuring tax agent services are provided competently. And Code Item 9, which is taking reasonable care to ascertain a client's state of affairs. Not doing proof of identity could also influence the fit and proper requirement, which is the fundamental requirement to be a tax and BAS agent. There's also Section 50-20 of the Tax Agent Services Act, which is a civil penalty provision that registered tax and BAS agents can breach if they knowingly or recklessly make statements or lodge documents with the ATO that are false, incorrect, or misleading. And I'll actually talk about that in one of the case studies later on today. So we're aware that most of you are already undertaking client verification checks and probably already, have been for many years. So our requirements are really aimed to make the processes contemporary and consistent and streamlined across the profession. We expect you to undertake proof of identity prior to providing tax and BAS services. Although for existing clients, you should undertake proof of identity as appropriate, and I'll talk about the logistics and timing of that one a little later too. So let's look at what information you need to verify clients or their representatives seeking to engage you as their agent. So for individual clients, you need to verify either their full name and either their residential address or date of birth. For individual clients using a representative, and that could be a spouse or a parent or a friend, you do need to verify both the client and their representative's full names and either their residential address or dates of birth. And you also need an authority for the representative to engage you on behalf of the client. Now, for non-individual clients, so here I'm talking about companies, trusts, partnerships, etc., they will obviously have an individual representative. So you need to verify the individual representative's full name and, again, either their residential address or date of birth. And you need to also verify the non-individual or the company, the trust, the partnership. And you can do that by verifying their ABN, ACN, or any other details that can help you to reasonably assess, using your professional judgment, the legitimacy of this entity. And you also need an authority for the individual representative to engage you on behalf of the non-individual client. So what evidence should you cite to validate a client's identity? For individuals and representatives, one primary photographic identification document will be sufficient. And that could include a document such as a driver's license, a passport, whether that be foreign or Australian, or a government proof of age card that are issued by our, I think, roads and transport people. If there is no photo ID, you can use a primary non-photographic ID, and a secondary ID will also need to be cited. So primary non-photographic ID includes documents such as a birth certificate, a citizen certificate, a pensioner concession card, or a health card. A secondary ID could include something like a Medicare card, council rates notice or a utilities bill, they need to be within the last 3 months. They need to be, recent, or it could be an ATO or other government agency notice that has been issued in the past year. For an individual under 18, you can get a letter from a school principal issued in the last 3 months that details the individual's name, residential address, and when they attended the school, or even a student card if it's available. To verify the authority of individual representatives to act on behalf of another individual client, you can use official or legal documents such as an enduring power of attorney or a letter of authority. If you need to verify a parental or a guardianship relationship, you can cite birth certificates, adoption papers, court orders, again, a letter of authority, or in some circumstances, a signed doctor's letter with an explanation of those circumstances. To verify the authority of an individual representative to act on behalf of a non-individual client, so again, companies, trust partnerships, you will need documents such as a copy of board meeting minutes documenting the appointment, or ABR or ASIC details, extracts, an employment contract indicating the person's position, so it could be, for example, tax manager, CEO, and you can also look at things like website information or other corporate or organisational documents where the representative is clearly identified as holding a relevant role to the management of the business's taxation, super or finance function. So, CEO, CFO, tax manager, general manager, etc. Either original documents or certified copies of original documents can be used for the identification process. Now, importantly, you do need to make sure when you're citing the documents that the photo in the ID document appears to match the details and the appearance of the person or the client or their representative that you're dealing with. So if you're unsure, don't hesitate to ask for another ID document. Also, make sure you check the name, the address, and the date of birth all match the information provided by the client or their representative. They can get quite clever with fake IDs these days. As I mentioned before, the TPB have worked really closely with the ATO to develop these requirements in order to minimise any burden on you and also streamline our processes. So where you have followed the ATO's approved method for client verification, you will also generally meet the TPB's requirements as well. Now, we know it's not always possible to cite identification in person, and often you'll need to rely on electronic means of communication. So there are various ways you can safely and securely obtain identifications electronically. One thing we strongly recommend is do not use email for communicating sensitive information. So, please do not ask your clients to email you a driver's license or a passport information unless you are using password protected or encrypted attachments. As you know, email is not considered a secure form of transmission, and there is a risk of emails being intercepted by third parties during transmission. Other ways you can organise to obtain IDs from your client include secure websites, secure online mailboxes, secure messaging, and secure client portals. If you're unsure, we recommend that you obtain professional advice from an IT security provider as to what controls are appropriate for your particular business. If you engage with clients remotely, you can use a webcam, video conferencing, or even FaceTime to cite documents. And in circumstances where you engage with clients purely online, So there's no visual medium, and, potentially they're putting details into your website, for example. You should refer to the ATO's approved methods for verifying identities. Now, when you're undertaking the proof of identity checks, if you identify any discrepancies with the information provided or claimed by the client or their representative, or even if something just doesn't feel right, ask more questions. Ask for additional documentation or evidence, another form of ID, or even see if you can independently verify the information that's been provided to you. If you are still unable to verify or are not satisfied with the information provided to ensure the identity is correct, you should decline the engagement. You should also then consider notifying the ATO, ASIC, or other relevant authorities. Now let's look at some situations that aren't as vanilla. So if a client doesn't have the standard ID documents, we suggest you take a flexible and pragmatic approach. Use your professional judgment. So some of these clients, it could be, for example, they're from remote areas. It could be they've just been affected by a natural disaster. They could have come to Australia as refugees. They might have limited access to identity documents if they're experiencing something like family violence. And clients who have had identity documents that have recently expired. So it could be, an elderly client who hasn't renewed their driver's license, for example. In these situations, we understand that you may not be able to apply all of the required checks that we've been through. And so what we say here is just maintain records outlining those specific clients' circumstances and the details of the steps that you have taken to establish the client's identity. So if I take the elderly client with the old driver's license, it could be that you say, I met with Mrs. Smith. I've met with Mrs. Smith every year for the last 20 years. Her driver's license expired 5 years ago, blah, blah, blah. So, and the date and the time. And if you do need any additional guidance on these outside of the square scenarios, have a look at the AUSTRAC website. They have some really useful guidance that you can use. Now, what about existing clients? And I touched on that a moment ago. We understand that you will have had clients that you've provided services for year on year and have a really well-established relationship with. For these clients, while it may not be practical or even necessary to conduct proof of identity checks, we recommend that you, in the very first instance, assess the need to conduct a proof of identity check on them. To make this assessment, you need to consider some of the following things. So the first one would be the extent of your relationship and your familiarity with the client. So, for example, my client, my son, do I need to do a proof of ID on him? Probably not, because he's my son. But what I have done is documented it in the system that on this day at this time, this was my professional judgment. Take into consideration the scope of the services that you're providing to the client. Take into consideration whether the engagement and the interactions with the client take place online, or if they're in person, or if there is a combination of both. Obviously, when you're dealing with a client in person, particularly if you're maybe going to their home, those situations can be very different than if it's a online only engagement. Also take into consideration whether the client or their representative is requesting a change of details. So it could be a change of contact details, or it could be a change of bank account information. Could be that they're asking you to amend tax returns or statements which result in higher refunds. Also be aware if they are communicating with you in an unusual way. So you might have an elderly client, they always ring you, and this time it's an email. And you think, I don't know, I don't think Mrs. Smith even has an email address. So take all of those things into consideration. Also, has there been a change in circumstances, or do you see any discrepancies in relation to their affairs, or does something feel off or unusual? Has there been a change in the relationship between the client and their representative? And this is, quite common when we're looking at, say, the husband and wife scenario, or even an employee and employer scenario. Whether there has been a continuity in the client's engagement with you, or has there been a break in the engagement? So, they might have been with you for 5 years, they've gone for a couple of years, and they're coming back. And we have seen situations in the board conduct committee where the client has come back, but it was actually not that client, and they were only dealing over email. So, be aware of those scenarios. And if applicable, are any of the what are the requirements from your professional association, or if you're under an AFSL? So these factors can all guide you in determining how often you should undertake the proof of identity checks for existing clients. And if following your assessment of the situation, you decide that a proof of identity check for an existing client or their representative is not immediately required, as I said earlier, keep a record of all the factors that you considered in making that decision. As always, tax practitioners are expected to rely on their own professional knowledge and expertise in making these assessments. Now, I'm going to hand over. We're going to do a quick poll now on proof of identity.
Thanks, Deborah. Give you a little breather. So the first poll that we've got for you now is just asking about some evidence and records that you keep. So what we'd like to know is, what records should you keep as evidence to show that you've undertaken the POI check? So we've got a few options for you to choose from there. First of all, we've got date and time the POI checks were done, type of identification documents cited, how the documents were cited, who performed the checks, and their position within your practice. The next option we have is all of them above, and then we have none of this is required. So I'll just launch this for you. That should just pop up on your screen now, and I'll give you some time to put through your responses, and then we'll come back and we'll share the results with everyone. People are getting onto this one pretty quickly. We've got 50% already, but I will keep it open for a little bit longer just to give you all a chance. And just put through your responses.
Now, I can see in the questions, people coming through asking if this relates to tax and BAS agents. And I should have said this at the very beginning. When I say tax practitioners, I'm actually talking about tax and BAS agents. Both need to be doing proof of identity.
Thanks, Deborah. I'm just going to close that now. So the poll's ended. I'll share those results. So they've popped up there on the screen. Hopefully you can see those, Deborah. You got those? Yep. Okay.
54% of people said all of the above. Well done, everybody. So proud.
Excellent. Well, I'll stop sharing and I'll hand back to you. Thanks, Deborah.
Thank you. And that's right. The correct answer is all of the above. And before I go any further, I do want to say we do not require, and importantly, do not even recommend that you keep copies of any copies or originals of any personal identification documents of clients or their representatives. In fact, we strongly discourage this practice because we recognise that these documents may be at risk of being stolen through either cyber attacks or even physical break-ins at your premises. So this recommendation of not keeping personal identification documents is consistent with the Office of the Australian Information Commissioner's guidance, particularly in relation to Australian Privacy Principle 11. So, although we don't want you to keep the personal identification documents, we do require that you maintain a record, such as a checklist for all of the proof of identity checks that you've done. And this should note things such as the date and the time that the checks were done, the type of identification documents and whether they were original or copies. So here, when we say the type, it might be, for example, New South Wales driver's license. And, you know, if you want that a little bit of extra assurance, don't write the whole number down, but maybe put, you know, XX in the last 2 digits or something like that. How the documents were cited. So did you do it in person? Did you do it via webcam? Were they sent to you via a portal? Or did you use a document verification service? And I can see that some of the questions in the chat are, can we use document verification services? And yes, absolutely, you can. The record must also include a confirmation that the identification documents were clear and legible and identify the client and their representative if applicable. And there also needs to be a confirmation that there was no apparent reason to question the identification documents provided. And again, if you decide not to undertake POI for a well-established client or a friend or a relative or a representative of any of the above, you must record your reasons why you didn't do the POI, along with the date, the time, and who in your practice made that assessment. And it's important that you record these details as soon as you do the POI checks or the assessment about not doing the POI checks. Importantly, you are required to keep these records for at least 5 years after the engagement with your client or that representative ceases. So that's 5 years after the engagement finishes. So take a note of that. Now, I promised you a couple of case studies. So the first one we've got is, where have we got here? Here we go. So this was an individual who solely engaged via an online platform. The tax agent did not undertake any proof of identity steps to validate the individual's identity prior to providing the services, which included lodgement of income tax returns. So the agent lodged the income tax return, and the ATO actually contacted the tax agent to advise that the identity of this taxpayer, who the individual claimed to be, had been compromised. Despite this advice, the tax agent re-added the taxpayer to their client list and continued to lodge additional tax returns on the taxpayer's behalf. In this case, the Board Conduct Committee found that the tax agent had breached Code Items 1 and 7 in that they lacked honesty and integrity because they re-added the taxpayer to their client list despite the ATO actually contacting them to let them know that the identity was a compromised identity, and Code Item 7 in that they did not undertake proof of identity checks prior to providing services. The BCC suspended the registration for 6 months and ordered this particular agent to consult an accredited cybersecurity expert to review their procedures on lodging tax returns with a focus on verifying client identity and dealing with potential identity compromise, and provide us with a report on the cybersecurity, from the cybersecurity expert, and advise us of all the changes made to their processes following that review. Now, case number 2, almost the complete opposite of online. So we've got Mr. Kim, and Mr. Kim's a tax agent, and he was visited by some individual people, representatives that he'd never met before, and they asked him to prepare 79 income tax returns based on information that they provided. I can't remember the exact situation, whether it was people from their community or an employer they were, but they said to Mr. Kim they had a very convincing reason why they had 79 income tax returns for him to prepare. The individual representatives provided Mr. Kim with PAYG payment summaries and bank account details. And it turns out that those payment summaries were false, and they had resulted from identity theft. The real identities and the TFNs were used to submit the false returns, which then resulted in the ATO paying refunds into the bank accounts that had been supplied by the people that walked into Mr. Kim's practice. Many of the returns lodged by Mr. Kim included a number of anomalies or irregular claims, so things like claiming a spouse tax offset, as well as doing returns for people that had left Australia permanently. Interestingly, had Mr. Kim checked the client's pre-fills, he would have seen many of the discrepancies that the ATO found. So in this case, the Board Conduct Committee found that Mr. Kim had breached Code 1, 7 and 9. So he misled the TPB and the ATO in his responses regarding the circumstances under which he lodged those income tax returns. So that was honesty and integrity. He also breached Code Item 7 in that he failed to obtain the correct information from taxpayers regarding their eligibility to claim things such as offsets, as he made no inquiries with the taxpayers. And Code Item 9, he failed to take reasonable care to ascertain the state of affairs of taxpayers who said, as they did not even meet Mr. Kim, and there were no grounds to question the information that he had received. Now, interestingly, in this one, we also applied the section 50-20 of the TASA of being reckless as to whether statements in the relevant income tax returns that he prepared were lodged false, incorrect, or misleading. And so the federal court did a civil penalty, found a civil penalty breach of the TASA, and ordered him to pay a civil penalty of $4,000 in addition to covering the TPB's costs to go to court. The TPB also terminated Mr. Kim's registration and imposed a 3-year ban on reapplying on the basis that he had failed to meet the fit and proper requirement to be a tax agent. So, yeah, that's it on proof of identity for this afternoon. I almost said this morning. And now we're going to go and talk about some engagement letters. So before we do that, let's actually ask the question of how many practitioners in our audience are currently using engagement letters. Over to you, Julie.
Thank you so much, Deborah. You've already asked the question, so I'll launch that poll, and it's a nice, quick, easy one this time. We've got 3 options there. Yes, I use them for all my clients. Yes, but I only use them for some of my clients. Or no, I don't use engagement letters for any of my clients. So just give you a couple of seconds to pop through your responses, because this is quite an easy one to answer. And then once again, I'll share those results so they'll pop up on the screen for everyone to see. Okay, thanks everyone for popping through those responses. I'm just ending that one now, and I'll share those results. So Deborah, you'll see there, hopefully you can see those results popping up, but we've got 61% of people saying that yes, they use them for all of their clients. 31 have said no, sorry, yes, they use them, but not for all the clients. And 8% have said no, they don't use them. So I'll hand back to you and you can share your thoughts on that. Thank you.
Thank you for that. Well, I hope for those of you who aren't already using them, I hope that after today's session, you'll maybe appreciate the importance of engagement letters, not just to you, but to your clients as well. And even the simple engagements. I mean, these are the ones that you think, oh, there are, you know, I don't know what people are charging now, $100 for a simple income tax return. That $100 income tax return can become a real headache and cost you a lot more money if you didn't have a letter of engagement in place if there is a problem down the track. So let's talk about engagement letters now. So let's start with the basics. What is an engagement letter? So an engagement letter is the starting point in the ongoing relationship and the communication between you and your clients. It can be used to clarify your responsibilities and also those of your client, their responsibilities to you, and can assist in avoiding disputes over fees and also about the scope of work that's agreed. It's the TPB's view that engagement letters are important because they're a simple way to set out your business practices and clearly outline what a client can expect from you and what you can expect from your client. When we receive complaints about tax practitioners, we often see that they haven't been using engagement letters, and they haven't expressly laid out the conditions of their engagement with clients. So our very first question to a complainant or to an agent that we're speaking to is, do you have a letter of engagement? And honestly, most complaints would have been resolved without us had there been a letter of engagement. And a lot of complaints that come to us are resolved because we then refer them back to their letter of engagement. So using letters of engagement is a really simple way to set out your business practices, to assure your clients that you are compliant with the requirements of the Tax Agent Services Act, including the Code of Professional Conduct, and to assist in avoiding uncertainty and misunderstandings, especially in relation to dispute over fees and the scope of work to be completed, which seem to be two of the biggest areas of concern. They're a useful tool to help you maintain an efficient and effective and an ethical practice. They set out the terms and the scope of the professional service that you will offer your client, and they advise your clients about their rights, and just as importantly, they can advise clients of their obligations to you and to the tax system. They're also an invaluable reference point or a starting point in case of any future questions around expectations from you or for them, and also in the case of fee disputes. In short, engagement letters can save you a lot of time and a lot of heartache in the future should there be a dispute between you and your clients. Importantly, engagement letters do not need to be complex, especially if you're dealing with simple tax affairs. However, as I said before, even in the most simple of dealings, an engagement letter will ensure you and your client have clear expectations and there is no misunderstanding of the services being provided. Are engagement letters required by law? No, they're not, I think is the short answer, although we do highly recommend the use of engagement laws. They aren't a specific requirement of the Code of Professional Conduct, and therefore they're not required under law. It's also important to consider that if you are a member of one of the recognised professional associations, your association might require you to issue engagement letters as a membership requirement. There are also other legal and professional standards and regulatory requirements where engagement letters may be necessary. So, for example, the Accounting Professional and Ethical Standards Board and the Auditing and Assurance Standards Board have their own various requirements relating to engagement letters. That said, the TPB's view is that engagement letters are really important and can be an effective tool that can be used to assist you in meeting can help you to meet the requirements of the code more generally, and can also ensure that you and your clients have a shared understanding of what is expected from the engagement. I'll note here as well that given the nature and implications of engagement letters, you may consider obtaining legal advice in relation to the letters of engagement you provide to your clients, particularly if they are complex engagements. And for those simpler stock standard engagements, many of the professional bodies have templates that you can access via a simple Google search, even if you're not a member. So when should you issue an engagement letter? And should it be a one-off exercise? The best time to send an engagement letter is when you're engaging a new client, when things are happy, things are fresh, and they're very willing to, do what they need to get you as their agent. However, it's also really important that existing clients always understand the terms of engagement. So whenever there is a change in the terms, it's important that you update your engagement letters, and this helps to avoid misunderstandings between both parties. If no update to terms are made, we still recommend that you send engagement letters annually to clients to reinforce the terms of the engagement. And this also accommodates any changes in the business relationship over time with your clients and strengthens the legal basis of the letter of engagement document. Sending engagement letters definitely shouldn't be a one-off exercise, and we strongly recommend that you reassess your engagement letters regularly. As I mentioned earlier, we recommend doing this at least annually and to update them whenever there are significant changes to the engagement or to your client circumstances. What we don't recommend is a set and forget engagement letter process. And, for example, you should also issue new engagement letters when there are changes to your standard terms of conditions, whether there's change in your scope of services, law and regulation changes, such as the new code requirements, if there's a change in your fees, if there's a business structure change for you or a business structure change for your client, and whenever there are changes to the client's relevant personal circumstances. And again, that could be, getting the letter of engagement if there's a change, they've gotten divorced, and we also need to get new letters of authority, those types of situations. So when you first develop an engagement letter, as a minimum, you should be including some of these things. What's going to be done? Who will do it? How will it be done? When will it be done? Where will it be done? Will it be done in Australia? Will it be done offshore? How much the work will cost, or how it's calculated, and the frequency of billing and the time frame that you expect for payment. Also, you need to include your name and the registration number, so it gives clients certainty that you are registered with the TPB, and also feel free to include your registered tax practitioner symbol. You need to outline how you will manage client information and maintain confidentiality, and if information will be disclosed to third parties. Now, this is one people go, oh, I'm not disclosing it to anybody, but please remember that third parties include software, and I'll touch on that a little later as well. You should also include information about arrangements for storing clients' documents or making copies of them. We recommend that you include information about your responsibility to provide services in a competent manner and within agreed timeframes, including lodging documents with the ATO. You should also include your professional indemnity insurance arrangements and how you will deal with tax refunds if you receive them on behalf of a client. It should also inform clients about their rights and obligations, and this may also include what the client's responsibilities are. So things like to make all relevant information available to you as their tax or BAS agent in a complete and timely manner, to advise you of any changes that is relevant to the services that you provide, advising them of the consequences of errors and omissions from information given to you. And if there are any items a client wants done that are not within the scope of the work agreed, what is the process that should be followed, and will there be additional costs? Confirmation of any specific lodgement requirements and timeframes that the client might have, and any rights and obligations of the client under tax law. And as a plug, we have some great PDFs that you can simply attach to your standard letter of engagement, which go through many of these things, along with advising them of the ramifications to you as their agent and your registration. And we do have one for both BAS agents and tax agents. They are different. And yeah, feel free to attach those, and they are on our letterhead. So I want to stress again, it's really important to reassess your engagement letters regularly, and it's important to use your professional judgment in considering the matters that are addressed in your letters of engagement, considering your practice and your engagement with each client, as not all clients or engagements are the same. Now, engagement letter resources. We are not able to provide templates or example engagement letters, but as I mentioned earlier, many of the recognised professional associations offer some great templates and examples to their members. So if you're a member, you can use those, and often if you Google search, you can use those as well. We do, however, have a lot of resources that can help you to stay on top of all that latest information. So our website, tpb.gov.au, is an awesome resource. You should bookmark that. And we have a practice note specifically designed to assist with engagement letters. You can also follow us on social media. We're on Facebook, LinkedIn, and Twitter, now called X. And each month we host lots of webinars like today, which are free to attend, and you can earn CPE for coming along. We do also record all of our webinars and upload them to our YouTube channel, and also have a monthly newsletter called e-News that you can subscribe to from our website. Now I'm going to have a look at technology, and let's have a look at what you should be aware of when using technology to help you stay compliant with client engagements. Now, more and more tax practitioners are using cloud computing to perform their work. You may be using cloud computing for a whole range of purposes. It could be for information storage. It could be for lodgement of returns. It could be to get digital signatures, or it could be client portals. And it could also be something like your practice management software. Whenever you enter into these cloud arrangements, you do need to be mindful of your obligations under the Code of Professional Conduct. In particular, mindful to Code Item 6, which states that you must not disclose any information relating to a client's affairs to a third party without the client's permission, unless there is a legal duty to do so. You must obtain permission from each of your clients prior to divulging client information to a third party, which includes the cloud service providers. And client permission can be by way of a signed letter of engagement, signed consent, or other communication. We do have some great guidance available on our website in relation to cloud computing, and Julie will share this with you all after the webinar. It's also important that if you are using technology, and I know most people are, to be aware of the threat of cyber attacks and the importance of proactively protecting yourself, your practice, and your clients. We've released guidance in relation to cybersecurity, and one of the ways that you can protect yourselves is whether you can, against cyber, is considering whether you should be taking out additional insurance cover to cover first-party losses that arise from a cyber attack. So these losses can include a denial of service attack, or the costs of rectifying any harm done, such as repairing and restoring systems that have been damaged by these malicious acts. We also recognise cybersecurity awareness training as a CPE opportunity for tax practitioners, because we know how important protecting yourself from a cyber attack is. So any cybersecurity training that you undertake will contribute to meeting your CPE requirements with us. Now, I'll touch on scope creep now and the role that engagement letters can play here. And we know and understand that this is a concern in the profession, but by setting out your fees and how they're calculated upfront in engagement letters, you and your client then have an agreed understanding of what is expected. It's also important that your clients always understand the terms of engagement. So whenever there is a change, it's important to update your engagement letter. And this helps to avoid any of those misunderstandings between you and your client that we've been talking about. By doing this annually, you can reinforce the terms of your engagement, and this accommodates any changes in your relationship with them over time. And as I mentioned earlier, strengthens the legal basis of the letter of engagement document. It's a great way to remind your clients of the scope of your engagement and can assist you with scope creep, where clients may, constantly be requesting small additions here and there that can accumulate over time and affect your resources and your budgets. As I mentioned previously, having a letter of engagement can assist where there is a misunderstanding about what was included and also what was not included in your agreed engagement. So, Julie, before we head over to questions, let's have one last poll.
Sounds like a good plan. Thanks, Deborah. So this one's a multiple choice question, and it's based on a scenario that you might encounter as a tax practitioner. So the scenario is Mark is a registered tax agent and he receives a tax refund on behalf of his client, Amanda. The money is deposited directly into Mark's trust account. In past years, Mark has deducted his professional fees from the refund money and then he's forwarded the balance to Amanda. Mark has not discussed the arrangement with Amanda this financial year, but they have an implied agreement based on previous dealings. So in this situation, do you think Mark should have asked Amanda to sign an engagement letter? So we've got 3 choices for you there, and they are yes, no, and unsure. So I've just launched that. Hopefully you can see that. I'll give you a little bit of time to pop your answers through. And then we'll come back and share that. Oh, sorry, everyone. It looks like that might not be working, that poll. Apologies for that. What we'll do is we'll just go to Deborah and she can give us the correct response for that one. Sorry about that, everyone. Thanks, Deborah.
That's a really interesting situation here, isn't it? Because you look at it and, at the very outset you go, but we've always done it this way. The issue here is if there's a dispute. So if Amanda comes back and says, I never gave permission for Mark to withhold my tax refund, unless you've got it in writing, you've got nothing to come back on. So it is really important that, you've documented somewhere, and a letter of engagement is a really good place to start. So he has done all the right things. He's deposited the money into his trust account. He kept it separate from his own money. He's accounted to his client on the basis, of the professional fees being deducted, all of those things. But again, if she denies any agreement, there could be a problem. So always better safe than sorry. Now, we'll go to questions, but before we do that, I will say that I can see in the questions online that, they're talking about things like if the client holds cloud software subscription, that's the client that's disclosing the information, not you. So, you don't have an issue there, but certainly all the software that you use does, you are disclosing information there. And the use of a letter of engagement before you start doing any of that is a great way to educate your client and notify them that this is what you are doing. So, yep, bring on the questions.
No worries. Thanks, Deborah. First question I've got here is, as tax agents, what is the penalty if ID checks are not done?
Okay, so there's not one specific penalty, and basically it depends on the situation and the extent of the situation. So, for example, in Mr. Kim's case, it was a very costly exercise of not doing those 79 checks, and he also lost his license or, you know, from the TPB for 3 years as well. So, you know, it really does depend on the circumstances of each and every case. But also there's a cost to the person that could be the victim of identity theft, and the cost to your business. So even if there's no penalty as such, you know, there can be reputational damage as well.
Thanks, Deborah. The next question I've got for you is about engagement letters, and this person's asking, do you need an engagement letter if you don't lodge the client's BAS? So if you're just offering advice, perhaps.
Look, it's always good practice to have an engagement letter. If, you know, they thought you were doing one thing and you were doing something, you know, else. And we all know that a tax agent or a BAS agent's language can sometimes be very different to what the business person or the individual hears. So when you've got it in writing, it's always something that you can go back to. And, you know, even I know in my own situation, you know, where you've said to somebody, oh, it'll cost between, say, $600 and $1,000. They come back and they heard 6,000, you heard 1,000. Sorry, they heard 600, you heard 1,000. So if you can go back to your letter of engagement and say, these were the things that were included in this, but then you asked for these additional things, it can certainly give you that point that you can go back to.
Great, thank you for that. I've got Karen asking here, if she's working for a small business, do I just need the ID for the business owner to do the POI?
So I'm guessing what you're saying there is it's a sole trader. If it's a sole trader, yes, you need the sole trader's identification. But if you're looking at say a one director company, you do need to identify the company and the director or the person behind the company, because that's who you'll be dealing with. So, you know, and, you know, an ASIC search will give you that information for the company, and then you can do your POI for the person.
Great, thanks, Deborah. Paula's question is, if we don't keep copies, and she's agreeing that we shouldn't, of the ID documents, and they just keep a file note, how does the TPB know that they've actually done the POI checks?
Yeah, look, the fact that you've documented it is always a really good start. And when you're documenting, you're putting the date and the time. And, you know, often your practice management software that you've put that in will date stamp that as well. So it's a contemporaneous, I always struggle with that word, log of what you've done and when you've done it. The other thing is, if you're using something like a document verification service, that time stamps it and dates it as well. But yeah, just make notes of it. And, you know, I mean, most people are doing the right thing, you know.
Thank you. Christine's asking us as well, Deborah, about well-established clients. And the question is, can we do a blanket list of well-established clients and the reasons, or do they have to be done separately?
Look, I think you should be, I think the thing you need to do is prove that you've turned your mind to that situation with that particular client. So, you know, I sit on the board conduct committee, and I would probably say a blanket of, you know, all these clients, no, I wouldn't do it if it was me, because I think you do need to turn your mind to each and every single one of those clients and what that situation is. And also, you've got to look at a whole range of things. How are you dealing with this client? Are you dealing through a representative? Are you doing it online only? Are you meeting that person face to face? So, there are always different situations for different clients.
Thanks, Deborah. We are running out of time, but I've got a couple of really quick ones that I still want to ask you. So I've got Jackie asking about POI checks, and the question is, do we have to do them every year?
Look, we recommend that you do them regularly. And again, that comes down to your relationship with the client. If you are dealing with the client all the time, so say you're a BAS agent, you're going in to see the client every month, every year is probably overkill. But if you've got somebody who is doing an online tax return with you once every 12 months, you never meet, it's appropriate to be doing it annually. So again, you can make the assessment. We haven't put it down as you must do this, but you can make the assessment and use your professional judgment. And as I said, in those situations, they were quite different. The level of engagement is very different.
Thank you. Another quick one is, should the person performing the POI check be the agent, or can one of the employees of the practice do that?
Anybody within your practice can do that. One of the requirements is, though, that you say who did it and what their position was in the practice.
Fabulous. Thanks, Deborah. And last question is from Paul, and he's asking, could you define letter? Is this limited to paper? What about online or email?
Yeah, look, I do use the word letter loosely. Because these days, often we're using, proposal software, for example. So it goes through an electronic means. So yes, a letter in the broader term. It could be an email, it could be through proposal type software, it could be a physical letter. And in some cases, when you're looking at those high volume walk in, walk out scenarios, I know that some of those agents have it as, it's on their counter and they are physically given to people as they walk in. So, yeah.
Great. Thank you so much for that. We'll leave the questions there, and I'll just quickly touch on some information on how to stay in touch. So if you do want some more information, you can jump on our website at tpb.gov.au. As Deborah mentioned earlier, follow us on LinkedIn, Facebook, and Twitter. We also have our e-news that goes out monthly. If you're not subscribing, highly recommend that you do that, especially in the current environment with so many changes occurring at the moment. So you can do that at tpb.gov.au/newsroom. You can also subscribe to our YouTube channel. I have had quite a few people ask today about recordings of the webinars. You'll find them there. And if you do subscribe to the channel, you'll actually get a notification each time we put up a new video. So you don't have to keep coming back and checking. You'll be notified as soon as something new goes up. And also, if you do watch a recording, you can claim CPE for viewing those as well. So that's really good for you to get some extra CPE. And I just want to say a big thank you to Deborah for sharing her insights today. That was a really great presentation, Deborah. Thank you so much. And also thank you to Nadia and to Daniel for assisting with the questions today as well. We do hope that everyone has found this session beneficial. And as we said today, it does count towards your CPE, and we will issue attendance certificates for those of you who have stayed online today. And then the last final thing for today is that we will be launching an exit survey, and we would really appreciate it if you could take the time to complete it. As I always say, it's very quick, just takes a minute of your time, and it's really helpful for us to improve on the webinars and gives us some ideas of extra topics that are interesting to you as well. So we're always looking for things that are going to help you. So let us know if there's anything you want to hear about from us. And the survey will just pop up in your browser when you leave the webinar today. Once again, thanks for joining us, and we hope to see you all again soon. Thanks all. Bye.
Bye.